Hello and welcome. On behalf of our entire staff at CUNY Citizenship Now, we hope that you are healthy, safe, and strong. I am immigration attorney Shawn Rahman, and I am honored to speak to you today about the many recent changes in the immigration law world of the past several weeks. Today, we have three main topics. Immigration application fees are increasing, and some by a lot, including for citizenship. And not only are the fees going up, application fee waivers are going away. Also, DACA is changing. After the Supreme Court saved DACA, the Trump administration is still trying to limit it, or perhaps even trying to end it. And three, the new public charge rules for obtaining a green card are on again and off again, and then on again for some. So many changes, it's difficult to keep track, but we'll try to make the best sense of it today. We have the latest for you on all these, and also a couple of USCIS application processing updates, followed by a brief Q&A session. As always, we'll try to get in as many questions as we can, but if you have a question, please type it in the comments, and we will answer them in this session or afterwards in our comments. Before we begin, we are excited and honored to announce that tomorrow, Thursday, August 20th, at the same time, 3 p.m., our amazing attorney, Marisara Quiñones, will present the first of our Facebook Live information sessions in Spanish. We want to acknowledge for today's session, our very generous sponsors, the Liberty Defense Project of the New York State Office of New Americans. The Liberty Defense Project is part of the New York State Office of New Americans, and they do amazing work to assist immigrants with access to legal services, regardless of status and income. One more announcement, we want to let everyone know that green card holders applying for citizenship can enroll in free citizenship exam preparation classes and interview practice. Again, free citizenship exam preparation classes and interview practice with the Citizenship Project run by the New York Historical Society. You know, CUNY Citizenship Now is proud to partner with the New York Historical Society in this effort. The popularity of these classes, these online classes, have grown immensely during COVID-19, and the reviews are just wonderful. You can do a search for the Citizenship Project, New York Historical Society, and you should be able to access an easy link for information, class schedules, and the registration form. You can also reach them at the Citizenship Project at newyorkhistory.org. Again, the Citizenship Project at newyorkhistory.org. All right. You know, at CUNY Citizenship Now, we have proudly provided our immigration law services remotely and virtually to hundreds of New Yorkers since the start of COVID-19. We are the nation's largest university-based immigration law provider, and our attorneys are ready to assist you with our immigration law needs, always free of charge. No matter what level of technology you have access to, no matter what level of technology you have access to share information with us, we will do everything we can to meet your needs. You can reach us by phone at 646-664-9400. And if you get our voicemail, please leave a message and we will call you back within 24 hours. You can also contact us by text at 929-334-3784, and also by email at citizenshipnowinfo@cuny.edu. Again, that's citizenshipnowinfo@cuny.edu. All right. Before we begin, we would be honored if you would just hit that share button right now so we can help spread the word of our services and the vital information that we provide in these Facebook Live talks. By sharing this within your networks, perhaps we can reach the person or family that can really benefit from today's discussion and also our services. And again, we will have a short Q&A session at the end of our presentation today. So please go ahead and ask your question in the comment section right here on Facebook. All right, on to the updates. Immigration application fees are going up, and fee waivers are going away, and there is no good or happy way to discuss this. On August 3rd, the Department of Homeland Security announced changes to the fees that USCIS will charge for various immigration applications. Essentially, many fees are increasing, and some drastically, including the fee for the citizenship application. On top of this, fee waivers are being eliminated for citizenship and green card renewals for almost everyone. You know, the courts have blocked similar efforts by USCIS before, but right now it's just not looking good that this is going to happen again. So unless the courts step in to block USCIS this time around, the fees will change on October 2nd. This means that any new application must be postmarked by October 1st to qualify for the current fee and the fee waiver. So let's talk about the most important of the fee increases, the one for citizenship applications. The fee for citizenship, this is the N400 application for naturalization, is increasing from $725 to a painful $1,170. This is over 61%. And to add to this pain, USCIS has substantially limited the availability of fee waivers for low-income permanent residents who are trying to become citizens. Currently, green card holders receiving a public benefit like Medicaid or food stamps or housing assistance can get their citizenship and green card renewal fees waived. Effective October 2nd, not anymore. Green card holders who can today show that they are experiencing a temporary financial hardship, perhaps because of recent unemployment, even COVID-related unemployment or high medical bills, can get their green card renewal and citizenship fees waived. Effective October 2nd, not anymore. This is particularly disappointing, this point, because, and it's even cruel, because it delays and probably will prevent many thousands currently experiencing financial hardship from becoming citizens just because they can't afford the filing fees. You know, the complaints that advocacy groups raised that people shouldn't have to choose between citizenship and paying bills or buying food, apparently not a concern for USCIS. It is what it is, I guess. There is currently a reduced fee option for citizenship for those who don't receive a public benefit, but also fall within certain income guidelines. Yes, that too is going away. Finally, and here is perhaps the most shocking change, right now, green card holders with households that make less than 150% of the federal poverty guidelines get their fees waived. On October 2nd, this will no longer be available. Applicants who, on October 2nd, applicants will no longer qualify, these applicants will no longer qualify for a fee waiver, no matter how little they may be earning. I want to just put this in perspective here, okay? A family of four making $33,000 total and all seeking citizenship, like a family that we recently assisted at Citizenship Now, would qualify today, or did indeed qualify today to to have their fees waived. But on October 2nd, this family would have had to pay close to $4,500 total on just the application fees. All right, and I shudder to think how long this family would have had to put off applying for citizenship if they were now forced to choose instead, perhaps medical care or food, or an immigrant couple making $25,000 a year together that is seeking citizenship will now have to pay an average of 11% of their annual take-home pay to apply for citizenship. That's just appalling. And I got this from a colleague of mine at a meeting this morning, a couple who lives paycheck to paycheck, who somehow manages to put away $20 a week to save up for their citizenship application fees, will take over 2 years to come up with the money. You know, again, there's just no good way to present this information. There are a very small number of exceptions that will still be eligible for income-based fee waivers, but this is only going to be reserved effective October 2nd for immigrants who got their green card through special programs like VAWA, the Violence Against Women's Act, or TPS, temporary protected status, or were survivors of trafficking as T non-immigrants, or perhaps of crimes as U non-immigrants. And the only reason USCIS is making these exceptions for these categories is because they are forced to by the law. All right. Not all fees are going up, though. Okay, some, like the green card, are actually going down, and for the green card renewal, the fee is actually being reduced from $540 to $415. But the burden will still be significant for so many without the fee waiver. Now, why is USCIS doing this? Well, very publicly, they have said that their revenues, over 95% of which come from application fees, are down significantly. This is no accident, folks. Should it surprise anyone that an administration doing everything it can to bring the immigration system to its knees is starving the agency responsible for immigration? You know, at Citizenship Now, we are working tirelessly to get the word out about these changes, and we are prioritizing cases with the largest fee increases and those who will no longer have a fee waiver option, and we will resume all other services on October 2nd. Again, at Citizenship Now, we are working to prioritize these cases and the applications with the largest in fee increases and those that will no longer have a fee waiver option. So let's all make a push to get as many citizenship and green card applications into the USCIS queue before October 2nd. Again, all applications postmarked before then, October 1st, the latest, still can qualify for the current fees and fee waivers. And again, we are reserving most of our appointments for green card holders that want to get their applications in before the October 2nd increase. We are also recommending that all applications mailed close to or on the October 1st postmark deadline obtain some proof of mailing from the Postal Service. You know, a registered mail with return receipt, or a stamped proof of mailing from the postal clerk, that comes to mind. This is to avoid possible problems later in case USCIS says it was mailed too late. Another option for you, and this has happened before, because applications that get held up in the mail, especially with the current reported service delays, postal service delays, this is highly recommended. I apologize for the noise, of course. They want to start doing construction on the street right in the middle of this Facebook session, but I hope you can hear me. I'll still plow through this. Again, we recommend that registered mail, if you're mailing it close to the postmark and you are concerned that you will have made the deadline, we recommend some form of registered mail or a stamped proof of mailing from the postal clerk, okay? Again, please call us to set up an appointment. We will help you with your citizenship application, your green card renewal application, your work authorization card, your replacement citizenship certificate, all of these before the fees changed. Here are our numbers again: 646-664-9400. Again, 646-664-9400. And if you get a voicemail, again, please leave a message and we will call you back within 24 hours. Again, our text number, 929-334-3784. And you can also contact us by email at citizenshipnowinfo@cuny.edu. All right. Let's switch gears here and talk about DACA. You know, this should have been one of the happy updates, you know, except it seems USCIS is very blatantly ignoring the Supreme Court's decision on DACA. Now, while the Supreme Court's decision on June 18th should have restored DACA in its entirety, a recent announcement by the Trump administration and Homeland Security has once again thrown the program and DACA recipients into a bit of limbo. To recap, there was the June 18th decision by the Supreme Court that rejected the Trump administration's 2017 attempt to terminate DACA, finding that the way it was terminated was unlawful and ordered the decision be sent back to the Department of Homeland Security. At that time, almost everyone seemed to agree that the decision should have resulted in the restoration of the original 2012 program that would have required USCIS to accept both initial and renewal applications from DACA recipients. This is what the Supreme Court said in their ruling. But no, not this administration, right? The Department of Homeland Security is unlawfully ignoring this decision. On June 28th, over a month after the US Supreme Court decision, Homeland Security issued a new memo or guidelines limiting the DACA program in this way. First, it eliminates DACA eligibility for applicants who have not received DACA in the past. Homeland Security stated that all initial requests that were previously submitted or are submitted now will be rejected and the fee will be returned. Again, the Supreme Court decision should have reinstated initial DACA applications. Second, Homeland Security has eliminated the possibility for DACA recipients to be granted advanced parole. That's the special permit for international travel, except in exceptional circumstances. Advanced parole was available in the pre-2017 version of DACA, to which the Supreme Court ordered the return to. And finally, the Department of Homeland Security is still renewing DACA for those who currently have it, but it has changed or reduced the renewal period duration of protection under DACA from 2 years to 1 year. So for those that were hoping to apply for DACA the first time, it certainly is not good news. USCIS refusing to process any initial applications. In fact, they are going to, they were, after the Supreme Court decision, those were held until DHS, Homeland Security decided the next step. They are now, unless there's another court order preventing these denials, initial DACA is going to be denied. For those who currently have DACA or had DACA in the past, yes, you still can renew. USCIS recommends that individuals submit DACA renewal requests between 150 and 120 days before your current DACA expires, but they do accept DACA renewal requests filed earlier than 150 days from the expiration. At Citizenship Now, we recommend that if your DACA expires within the next 5 months, you consider renewing it now to ensure your request is processed before your current DACA status expires. If your DACA expires in more than 5 months, please give us a call or speak to an immigration attorney or DOJ accredited rep to get an individualized assessment about the benefits of and risks of applying for your renewal early. It's important to remember, though, that your new DACA period will start from the day that your renewal is approved. So applying early may lead to an actual overlap between your current and new 1-year DACA issuance, right? And we want to help you maximize your DACA status as long as possible. So please speak to an attorney, give us a call if you have any questions about this. And again, those who applied for DACA, for a DACA renewal before the July 28th memo from the Homeland Security, all applications that were pending when the memo was issued will be processed under these new terms. And unfortunately, that means if you are still waiting for an approval notice and a 2-year extension, your DACA renewal extension will only be for 1 year. Again, I profusely apologize for the noise. I live in a 100-year-old home with not much noise insulation, and there is, of course, construction, very timely, if I might add. For DACA recipients seeking to travel on advanced parole, in the July memo, Homeland Security essentially rejected advanced parole requests from DACA recipients, except in exceptional circumstances. And unfortunately, it's not clear what USCIS considers an exceptional circumstance. The memo does state, though, that any approved advanced parole request will remain valid. If you are interested in applying for advanced parole or travel abroad, we urge you to please speak with an immigration attorney or a DOJ accredited representative before applying, and certainly before you travel outside the United States, even if you've already been granted advanced parole. Just want to give out the numbers once again. They are 646-664-9400. And here is our text, 929-334-3784. And of course, by email, once again, citizenshipnowinfo@cuny.edu. All right. So that is about DACA. Let's go to public charge. Public charge updates. All right. Mixed news on this one, folks. But still positive for now, particularly for those living in New York, Connecticut, and Vermont. On July 29th, a federal district court issued a nationwide injunction which blocks the new public charge rule from going into effect for as long as there is a COVID-19 national health emergency or declaration in effect. The rule was temporarily blocked by this decision. However, just last week, another court ruled that the nationwide injunction was too broad and that only those seeking green cards in New York, Vermont, and Connecticut were not subject to the public charge rules for now. To provide you some quick background and context on this, you may recall that on August 2019, the federal government announced a new rule related to when certain immigrants might be considered a public charge under immigration law. That rule will prevent some immigrants from getting LPR or green card status or a visa if they use certain public benefits, or the federal government believes that they are likely to depend on public benefits in the future. On July 29th, again, this rule had been blocked by the court because of the National Health Emergency Declaration. Essentially, the court recognized how severely the rule continues to harm immigrant communities, many of whom are working on the front lines of COVID. And it also hinders our efforts to address the health and economic impacts of the pandemic. As the court ruled, no one should suffer punishment or penalty if they seek medical care or temporary financial aid as a result of the pandemic's impact. It's a matter of life and death that all immigrants in need of medical care, food assistance, and other benefits seek and receive the help that they need without fear. The court also ruled that the health insurance requirement for immigrant visas from abroad made little sense and put a hold on that requirement. That part of the public charge rule required those applying for immigrant visas to the United States show that they have approved health insurance to avoid being labeled a public charge. The plaintiffs in this case argued successfully that the insurance requirement amounted to a little more than just a wealth test that would have forced working immigrants to choose between vital services or remaining together with their families. So listen, we're not in the clear yet with public charge. The administration is likely to appeal the injunction and the decision. again, it was then that it was through the injunction that it was narrowed to only New York, Connecticut, and Vermont not being subject to the public charge rule. But for now, immigrants that were subject to the new public charge rules in these states can access life-saving benefits without fear. All right. To recap, also I want to mention immigrants who are sponsoring a family member abroad or will travel abroad to apply for a green card or visa should know that there was also a public charge policy at the U.S. consulates. However, the July 29th federal court ruling also blocked for now the implementation of the new public charge rule at the consulates abroad. So the Department of State has stated that they will comply with the court's ruling. All right. Again, immigrants who are concerned about public charge should seek help from a qualified immigration law provider to make the best decisions for themselves and for their families. We urge everyone to learn whether the new public charge rule could have impact on you or your family before withdrawing from benefits that you are lawfully entitled to, and we want you to get answers to questions and on how certain public benefits may affect your immigration status. Okay. Again, our numbers: call us at 646-664-9400. You can also contact us by text at 929-334-3784. And again, by email at citizenshipnowinfo@kearney.edu. All right. Let's get to a couple of the USCIS updates before we take questions. I want to give a big shout out to my esteemed colleague, Attorney Tom Shea, for these updates. Thank you, Tom. Greatly appreciated. USCIS recently announced that it is going to furlough 13,400 of its 20,000 employees effective on August 30th or September 1st because Congress failed to reach an agreement on the coronavirus stimulus package, which was to include funding for USCIS. This furlough was originally slated for August 3rd. We learned in a call this morning that they are going to go ahead with this effective September 1st. Again, USCIS originally asked Congress for $1.5 billion to cover their budget shortfall, and is planning on adding a 10% charge to filing fees. Now, due to pushback, USCIS delayed that furlough to August 30th, but we learned today again that it might be on September 1st. The end result of this will be USCIS running at 25% capacity. And what are we going to do? What are we all going to do about this? Well, if you are planning on getting an application in, do it now. If this furlough goes through, processing times will get significantly longer than we can possibly imagine. Let's take a look at the current processing times. We haven't done that in a previous session. The I-485, that is the adjustment of status application. And these are New York based, range from about 11 to about 37 months in New York City. For the N-400, that's the citizenship application. Right now, they are ranging from 14 and a half months to a staggering 45 months in Brooklyn. And for the N-600, that is the application for a citizenship certificate that is ranging between 8 months and 15 and a half months processing time. So these are taken from the USCIS website. So if you are outside of these regions or in another part of the country, check it out in their interactive website. You should be able to just simply search processing times, USCIS case status, and get that as your first result. Just a few more of these more general or nationwide I-90 green card renewals. That's the 10-year green card renewal right now is taking anywhere between 9 months and 10 and a half months. A replacement green card is about 6.5 to 13 months. And the I-30 petition for a relative, this is the timeline. This is the timeline for immediate relative of a U.S. citizen, and by immediate relative I mean the spouse, and the parent of a child under 21 of a U.S. citizen. That range now is about 20.5 months to about 26.5 months. But for married children over 21 of U.S. citizens, that jumps to as high as 88 months right now. And this is before the furlough. So one or two more processing times before we get to the Q&A. We're getting some questions. We got a couple of questions by email. We're getting a bunch by text. We're going to try to get to them all. The I-751 petition to remove conditions on a green card by marriage. That waiting time right now is 12 to 35.5 months. I know a lot of people waiting for that for a long time. And an I-21D, that is for DACA renewals. That is right now 3 to 5.5 months. Again, these are pre-furlough where we are right now, okay? All right, that's it for now with the updates, and we hope to report updates or things that are going on at the USCIS regional offices in New York and getting through the COVID backlog the next time we meet in a few weeks. But for now, let's take some questions. Okay, we received a couple of questions by email. Let's get to those quickly. We have a CUNY graduate, also with a master's degree in geology, but her OPT expired. His or her OPT expired, I can't tell. I overstayed. Is it possible to assist me with work authorization? Okay. OPT. Okay, for the audience, OPT stands for Optional Practical Training. It's for F1 students studying. It's essentially temporary employment related to the student studies. To answer the question, generally, you have 60 days grace period after your OPT expires to change your status, to transfer your F1 to a new school, or to leave the country. But we would need to, I think we would need to learn a little bit more about your time frames, but urge you to talk to your student advisor, your last student advisor, about your options. We recommend that, but you should also speak to an immigration attorney to explore all your options to stay in this country. Obtaining a new work authorization will require a valid status, and it looks like your clock is ticking. Again, you have a 60-day grace period before your OPT expires. Okay, one more by text. I am a US citizen who applied for my fiance from Jamaica to come to the US so we can get married after him getting his K visa. I am afraid Trump's ban on visas will hold him and prevent us from getting married. What can we do? Okay. So there's a couple of things in your favor here. First of all, congratulations. Second, your fiance's K1 visa probably is not even considered an immigrant visa. So really there should be absolutely no reason your fiance visa petition should be held up. It's not an immigrant visa, except of course for COVID, right? COVID put a hold on everything. But things are starting to open up. We understand at the Jamaica consulate, services are limited though to emergency situations. Unfortunately, this probably does not yet mean the processing of fiance visas. So, you may have a long wait. You should be able to find a service update on the State Department's homepage for the Jamaica consulate. Each consulate office has their own homepage with a status of post-COVID services, okay? But there may be another option for you, depending on where you are in the process with your application for a fiance visa. You probably completed the I-129F application for your fiance's visa. And perhaps you can get a little creative here to speed things up. Turns out that immigrant visas for spouses of US citizens are not subject to the green card ban. So since you are a US citizen, and because the wait for your K visa or your fiance's K visa may take longer, perhaps you want to think about visiting Jamaica when you safely can and getting married there, and then applying for him as a spouse of a US citizen. That might speed things up for you. I know it's not what you planned. You probably had a great, beautiful wedding planned, but at least you can get married. You might be able to get married sooner and bring him here sooner if that's what you want. Again, congratulations and good luck to you. All right, let's get to a couple of the questions. So many questions through text. Can I apply for citizenship during COVID-19? Yes, you can. CUNY Citizenship Now and so many of our partners around the city have been working tirelessly since the beginning of the COVID-19 shutdown to provide our services remotely. Please give us a call. We certainly want to get your application in if you are before the October 1st deadline to get you the reduced fee, or I'm sorry, the current fee, or the certainly the fee waiver if you are eligible. So please go ahead and do that. Next question. I did my application right before COVID-19, but haven't mailed it out. Can I still do it now, especially now that the fee hasn't increased? Yes, you want to go ahead and mail it out right now. You want to make sure that none of the information in there has changed. You want to make sure that you have a current signature and date on it, but you absolutely want to get that in before the fees increase. How many years, next question, how many years before a green card holder can apply for citizenship? Essentially, you need, in most cases, to be a green card holder for 5 years, and you can apply 3 months early. So if you look at the date on your green card, for most people, you can apply for citizenship 4 years and 9 months after the date listed as on your green card is when you got your LPR, when you first got your green card. In some cases, if you are married to a US citizen and you stay married to them and you've been living with them for 2 years and 9 months, you can apply essentially 2 years early. All right. So again, if you are married to a US citizen, you can apply at 2 years and 9 months. And if you are applying on your own, you can apply at 4 years and 9 months. All right. I am not a citizen or a green card holder. I have a daughter that is a citizen. How do I apply for both? I am not a citizen or a green card holder. I have a daughter that is applied for citizen. It looks to me like you are asking here how you apply for whether your daughter can, as a citizen, can apply for you to get a green card. And the answer is yes. As a US citizen, she can petition for you. You would strongly recommend to speak to an immigration attorney to understand your particular qualifications in this case. All right, thank you. USCIS received my application for naturalization on March 2020. How long will it take before I get an appointment for biometrics? Oh, that's a great question. Biometrics for citizenship were, of course, held up by COVID-19, and only recently have they started working on citizenship and naturalization again. And what they've done, we understand, is started with the backlog of the oaths, the swearing ins, and are now opening up interviews, and we expect the biometrics appointments will follow right after that. Thank you. That was a great question. Let's see. Did they put a fee on the DACA form I-821D? Did they put a fee on it? There was always a fee on it. Perhaps you are asking about, there is a fee for DACA. Let's see. Do processing times change? Yes, processing times change, and they change often. Usually, we will see the changes on a monthly basis, and they very often go up and down. Okay. Next question. My citizenship interview approximate date was August of 2020, changed to September because of COVID. At least that was my USCIS account says. What is going on with citizenship interviews? Are they being delayed even further? We understand that interviews are resuming. And in many cases, we have heard about in a number of cases, we have heard about USCIS calling calling applicants to come in for their interviews with just a week's notice or even a few days notice. So just hang on. If they've given you a September date, hopefully they will stick to it. Right now, they have resumed citizenship interviews. So you have a date, and that is positive. Just hang around. Let's see. I was supposed to, one last question for now. I was supposed to go for biometrics on March 7th. Then the pandemic hit us. I've never received anything since then. What do you think I should do, please? If you are if you're applying for citizenship, then I think you'll have to just wait until they send you a new appointment. They are working through the backlog of all of these. And again, we do believe that the biometrics appointments will follow very soon. So you can always call USCIS for a status and do an inquiry that way. Unfortunately, right now, it is in order: the oath ceremonies, the citizenship interviews, and then the biometrics. We understand that they are working through the backlogs in that order. So they are getting to you. Recommend that you just be patient and just continue following up with them, okay? All right. This is all the questions that we have for now. Again, we want to tell everybody that we are with you. All of my colleagues and all of the wonderful people in our partner organizations are with the immigrant community here in New York and really in the United States and around the world. A number of the things that we presented today, especially the fee increases, frankly, are just going to be very painful. Hopefully there is an injunction and some relief coming our way, but until then, we are going to be we're going to be full steam ahead in trying to assist as many green card holders and immigrants that we can to get in their applications by the October 1st deadline. Thank you on behalf of all of us at CUNY Citizenship Now. Hope you are safe. Hope you are healthy. Stay vigilant and strong. Have a good afternoon. Thank you.